You think it is absolutely no accident that that was the date that this happened. Exactly 36 years before Maduro's capture, Noriega surrendered to U.S. authorities and is flown to Miami to face trial. Noriega raises multiple defenses. Head of state immunity. He argues that as the de facto head of state of Panama, he is entitled to immunity from prosecution. The court rejects this. And again, you're going to see this is exactly why the United States in 2024 decided at that time, after there was dispute over the election, that they were no longer recognizing Maduro as a head of state. And this is why, because they're going to make that the reason why they're going to say he should not receive head of state immunity privilege. And the court held that it can be withheld or granted, and that the U.S. had, and that one of the factors is that the U.S. had never recognized Noriega as Panama's legitimate ruler. Now, Maduro is a bit different because the world recognizes him as a legitimate leader. He was elected, even if it was disputed. And the question at hand will be, is it enough that just the United States government simply says, we're not recognizing him as a leader? Is that enough? And that's going to be up before the United States Supreme Court. That will travel through the Second District or to the Second District Appeals Court or Second Circuit Appeals Court. It's going to go all the way up, and that's going to be decided, and we'll see what they say. Illegal capture. Noriega argued that the manner of his capture through a military invasion was shocking to the conscience and in violation of the laws and norms of humanity. The court rejects this under Kerr-Frisbee, but you're going to hear the shocking to the conscience is what the basis is going to be, and it may be viewed a tad bit different here, and we're going to go over that. And then there was an extradition treaty violation. Noriega argues that his capture violated the U.S.-Panama extradition treaty. Citing Alvarez-Machain, the court rejects this, holding that the treaty did not explicitly prohibit the method by which he was brought to the United States, which is kidnapping. So that I don't know whether or not, I don't know what the treaty is, but I'm assuming that's not included in any extradition treaties. So again, a dangerous precedent that is set. If it's not included, United States courts are going to recognize it, and that means that what's good for the goose is good for the gander. It could happen to our leader if somebody decides to come in and get that stupid. But, you never know. Prisoner of war status. Noriega claimed that as a prisoner of war under the Geneva Convention that the court lacked jurisdiction. The court acknowledged his POW status, but held that the Geneva Convention permits prosecution for pre-capture crimes like drug trafficking. Noriega was eventually convicted in 1992 on 8 of 10 counts, sentenced to 40 years in federal prison. He served 20 in the United States. He was extradited to France in 2010, served a sentence for money laundering there, and then back to Panama in 2011, and he ended up passing away in 2017 at 83. Now, we break it down here for you, okay? And again, this is all on our website. Why this is a much different case. This is not Noriega 2.0. The parallels look similar, but there is a lot of differences. So let's go over them. Status. 1989. Noriega was a de facto military leader who never won an election. Maduro in 2026 is an elected president, regardless of how disputed that election was. I mean, after all, we have disputed elections here. So, this again is a very dangerous president, recognized by a majority of world nations. Declaration of war. There was no declaration of war by Maduro or Venezuela on the United States. Panama's National Assembly did declare war on the United States, making this a completely different situation. America's presence. There was 10,000 troops already stationed in Panama. There was absolutely no U.S. military presence in Venezuela prior to this invasion. Strategic assets. The United States had no comparable assets to the Panama Canal neutrality at stake. That was already something that was in effect. There's no comparable U.S. strategic asset near Venezuela or at Venezuela besides oil. Civilian casualties. Estimated hundreds of Panamanian civilians have been killed. Unknown but reported. Investigations ongoing. International response. The UN General Assembly condemned the invasion 75-20. Clearly, there's not been time for any type of UN assembly, but it's been at this point today, based on news reports, near universal condemnation, even by our closest allies like the UK, France, Germany. All of them have condemned this act. And the UN Security Council is apparently going to be convening a emergency meeting at some point in the near future. Congressional authorization, none in either case. And post-capture governance, U.S. recognized Guillermo Endara as president. Panamanian government continued. Trump announces that the U.S. will run Venezuela temporarily, which really throws a really different look on this, and not a good one for us. The critical distinction that's going to echo through the legal proceedings is that when the U.S. invades Panama, Noriega had declared war. American citizens were allegedly in danger that were in the area. Troops were already on the ground. And none of those conditions existed at all in Venezuela at the time this happened. One retired Army colonel puts it, there, and this is somebody who was quoted today, there were tens of thousands of Americans in Panama allegedly in danger. Noriega had declared war on the U.S., and neutrality and protection of Panama was at risk. And none of that is here. It's not even close to being the same situation. So the questions, let's go over the legal questions, because this is where we are concerned about right now on this channel. This is what you'll be watching. This is what you need to understand as a viewer of this channel, and someone who is concerned about due process, because it's in due process we trust. It's in due process that we believe, or I believe, my father believed, that ensures fairness, and that is what separates us from everyone else, is the belief and that due process applies to everyone, regardless of how heinous the action is, regardless of how terrible the crime is. Now, the first thing that's going to be is a battle over the U.S. non-recognition to strip head of state. The United States has not recognized Maduro as a legitimate president since the disputed election of 2024. But the question is, does that matter, right? Because, again, there might be some countries out there who witnessed some of our elections that were disputed. And would it matter whether or not this other country says, well, I don't believe that was fair? What authority does a country have to simply say, we don't recognize you, especially when the rest of the world does? In the Noriega case, the court held that the head of state immunity is a privilege which the United States may withhold from any claimant. But Maduro isn't a military strongman who seized power in a coup. Some might say he's a military strongman, but he didn't seize power in a coup. He was elected in 2013 and in several disputed elections since. He's been inaugurated. He's recognized by a majority of the world's nations. He's appeared on behalf of these countries as a head of state. He controls the government, the military, and the institutions of the Venezuelan state. Does America's decision to say, hey, we don't recognize you, automatically convert that leader from head of state into private criminal defendant? And if so, what would stop any future administration from simply refusing to recognize a foreign leader and then claiming the right to invade and arrest them? So this is something that is going to give great pause to the Supreme Court and to any judge who's deciding this. This is going to be controversial, and this is going to be something to watch for. And I can't wait to see how this plays out. The next thing is, at what point is capture too bad for good detention? The Kerr-Frisbee doctrine has survived, as you've seen, over the years. It survived invasion of a small Central American nation. It survived going into Mexico. But can it survive this? Because this operation involved airstrikes on a foreign capital. It destroyed military and civilian infrastructure. It killed civilians and military personnel. The exact number right now is being determined. It created a power vacuum in a country of 28 million people, and it was condemned by everybody. France, Germany, United Kingdom, these are some of our staunchest allies. The Second Circuit in the 1970s did create a narrow exception to Kerr-Frisbee. And it's important because this was in the Second Circuit, the same circuit that will hear this case if it once it heads out of New York District Court or out of the federal district court in New York. And it was in a case known as United States versus Toscanino. I encourage everyone to look this case up, suggesting that if capture involves the big T, I can't say it, you can see it on the screen, or conduct, and this is the important part, that shocks the conscience. Now, you can see why it's very important when you saw that picture of Maduro blindfolded, but he had a water bottle in his hand, that it's important that the big T is not something that happens, because in that case, in the Toscanino case, the court held that the actions that were taken prior to delivering to the United States were so bad that it shocked the conscience, involved the big T, and thereby he was not going to be tried. It's only been applied that I know of in the Toscanino case. But Maduro's defense is going to essentially, this is where we were just talking earlier, the shock the conscience is an invasion against all international laws, coming into a country, bombing. Now, the Trump administration is going to say, no, we were lawful. This is someone that was declared a head of the Big T organization. They're doing all these bad things, and therefore we went in as part of a lawful act. We don't recognize this individual as a leader. He came to power in a disputed election, and we were coming in to come get a criminal defendant. And regardless, again, shock the conscience. No, this doesn't shock the conscience because this is just what we had to do. But again, a judge in the Supreme Court is going to have to find out, is a military invasion of a sovereign nation without congressional approval, strikes on civilian infrastructure, and the capture of a sitting head of state recognized by the entire world as a head of state, does that shock the conscience? And if that doesn't shock the conscience, what in the world would? Okay? Now, when the other thing we're going to have to deal with, what happens when international law violations are as massive as what we have? Article 2, Section 4 of the UN Charter provides that member states shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. In the UN General Assembly's 1974 definition of aggression explicitly includes the blockade of ports or coasts by a state by the armed forces of another state as an act of aggression. That was committed in December. UN human rights experts already condemned that. That's already been condemned. So we have that. And they said there was no right to enforce unilateral sanctions through an armed blockade. I'm not here to say whether that was right or not. I'm just telling you that's what they did. A blockade is prohibited use of force by military force against another country under that article. The U.S. courts have historically held that violations of international law don't defeat jurisdiction under covert. The Supreme Court in Alvarez-Machain acknowledged that the abduction may be in violation of general international law principles, but held that was a matter for the executive branch, not the courts. In other words, that will be held. That's the responsibility to be handed out for the actions that were taken, but it doesn't affect his ability. If he's standing in the dock, if he's standing in the dock, if he's hearing the charges, if he's being given due process, that is the only thing that matters in the assessment of whether or not due process is being given here, and it doesn't affect. Say, hey, this is so terrible, he's not going to hold trial. But can the position survive when the violation isn't a covert kidnapping by hired operatives, but a full-scale military invasion broadcast live on television? So again, this is going to be a big deal here, okay? Because this is like a step up. There's been nothing like this done, and we're going to find out, will our courts rubber stamp this for the world to see? And when they do, what will the reaction be of the rest of the world? Like I said, this has massive, massive impact all over the world about what type of nation we are and how we view ourselves. Are we the lawless or are we the lawful? And we have to show the world we're the lawful. Was this an act of war requiring congressional authorization? This will be something I'm sure there will be congressional investigations on, and there will be a bunch of things I'm sure that will investigate this in the coming years. But the U.S. Constitution grants Congress, not the president, as we all know, the power to declare war. And that the War Powers of 1973 requires the president to notify Congress within 48 hours of committing armed forces to military action and to terminate such action within 60 days without congressional authorization. The Trump administration are right now pointing towards a 1989 legal opinion authored by then U.S. Attorney General William Barr that the president has constitutional authority to deploy the FBI to investigate and arrest individuals, even if those actions contravene international law. So this is important. I mentioned this earlier. FBI agents were embedded with the Delta Force. And the reason why is because that's the exception they're going to point to when they go and Congress is investigating, or if a judge is reviewing this as part of the Maduro's pleadings, and they're going to say, under the 1989 legal opinion, we had right to do this. We sent the FBI with them. This was for them to go in and arrest. This was not an act of war. This was not a coup. This was not an attempt to take over a sovereign nation. Democratic lawmakers, of course, have already come out, as you would expect, they're the opposing party. Senator Andy Kim stated that Secretaries Rubio and Hegseth looked every senator in the eye a few weeks ago during the congressional hearings they had and said this wasn't about regime change. He says, I didn't trust them then, and we see now that they blatantly lied to Congress. Of course, this seems to happen all the time, but there is a crime out there called lying to Congress. So we'll see how that plays out as this progresses over the years and this is looked back upon. Representative Richie Torres stated, the U.S. Constitution vests the power to declare war in Congress. No single individual has the authority to commit the nation to a war of regime change without congressional authorization. While questions of constitutional war powers don't directly affect this court's jurisdiction, they will color the entire proceeding, and they could affect the court's views of the legitimacy of the capture. In other words, if the court may view this as rubber stamping an act that they say, hey, this should have never happened. This was an act of war, and as a result, we're not going to rubber stamp this. And any ruling in favor of it would be essentially rubber stamping it. And with this being in New York, that's not a Trump favorable state. It's not a Trump favorable circuit. He hasn't gotten very good treatment there in his own cases. This could be, we'll see how they handle it. And then, of course, this is a big one. And this is the President of the United States. It's a fair trial. Sorry, I skipped the part. It's the fair trial principle. And the question is, I seriously myself am wondering this. The President of the United States, and this is the problem with something like this, there is no greater taking away of an individual's right to due process and fairness and a right to a fair trial. And when you have the President of the United States essentially saying this guy is guilty. This guy is so guilty we sent the military in. And I watched it. And we violated international law to go after him. I don't know how you could ever get this guy a fair trial anywhere, because essentially it's created the situation where you would almost be saying, you vote with Maduro. You vote Maduro not guilty, you're voting against your country. That the only vote for your country is guilty. Now, of course, opponents of the current administration and opponents of this whole situation might see things different, and that's why we would put them towards a jury. Now, again, to a jury. That's the magic of a jury trial. And Maduro, who I believe is a pretty brutal dictator himself, and I don't think he probably appreciates due process like he's going to appreciate it in this case, he's going to find that you don't just get to say guilty. 12 jurors come together and have to hear the case, decide the case, and decide the type of country we're going to be, and decide whether or not the laws have actually been violated, and decide how this goes. I don't know the strength of the case. I haven't seen the evidence. I'm not even going to comment on it. But I guarantee you they're going to ask for a change of venue, although I don't know where you would change the venue to. Whether it's, New York is no more worse than Chicago or D.C., okay? I don't know why New York would be worse than that. I don't know that defense attorneys would want to move it out of New York, but we'll see. But it creates a very interesting problem for getting him a fair trial. Now, then there's the global president problem. What do we mean by that? That if the United States can unilaterally invade sovereign nations to capture their leaders, what principles prevents other nations from doing the same? And if we can go and invade countries based on a domestic indictment, what stops Russia from doing that? What stops China from doing that? What stops them going in and taking out a leader that we find friendly? And where is our basis to object to it going to be? Because when we disregard the legal limits, as one scholar wrote before this invasion happened, in regards to other things that were happening, but if we disregard the legal limits on the use of force, it undermines the very norms that it relies upon for us to condemn this type of aggression elsewhere. It weakens our credibility as a nation when we're calling out invasions in Ukraine, and when we're dealing with, if China were to go and invade some of the territories that we have. Again, we don't want to make this too political, but the idea here is like Taiwan or look, these are things, or let's say North Korea went into South Korea. These are things that we have had the ability to talk against, because we have said there's a way to do this humanely, and there's a way we settle these things. And it is not this way. If we are going, And again, I guess it all fits in with why you've seen when Hegseth was making the changes to the military that he is, and he's trying to strengthen the military and get people in. You can kind of understand now why all of this is going on, because they're understanding that we are going to be inviting this to happen, and we are going to have to be ready to decide what we're going to do. And it's not going to be who settles this in court. Okay, that's where we're heading. French Foreign Minister Jean-Noël Barrot states the military operation, this is the French foreign minister, states that the